Morning.
Permission. Item number 1 and 2.
May I seek your lordship indulgence?
Just
My
one
lord,
second,
my
one
sen-
second.
Yes.
Yes, please.
My lord, my senior is on legs. If the matter could be passed over for the
Item
time
number?
being. 1 and 2. For the time being.
All right.
Item number 3.
Is the reply filed?
My lord, may I seek for further time to file the reply against the affidavit of the
Mr. Joseph?
My lord, I will also take some time to file a reply to the affidavit by respondents number 1 to 4 and also by respondent number 5.
All
my
right.
lord.
Mr. Joseph, so-and-so learned counsel for the petitioner seeks 2 weeks' time to
2 weeks.
file rejoinder to the counter affidavit filed by the
1 to 4
respondent numbers
1 to
1 to 4.
and also by the respondent number
And also to the counter affidavit filed by respondent numbers
5.
5. Mr. Lalramenga, learned counsel for respondent number
number 5, my lord.
respondent number 5 seeks
2 weeks time.
2 weeks time to file to file return in the matter. Prayer allowed, list after so and so on a date to be fixed by the registrar.
My lord, if the date can be fixed for 4th of October, my lord.
All right, 4th October.
Much obliged, my lord.
Item 4 to 10.
My lords, I'm
Yes.
appearing for the petitioners, my lords. The counsel for the ministry has, my lords, asked me to take her Passover, my lords. She's on
Passover
legs.
for the time being?
Yes, ma'am.
All right.
Item number 11.
RFA, is it admitted? Not.
It seems the appeal has not been admitted, my lord, and I'm appearing as a legal aid counsel for the sole respondent.
Even the appellant, Mr. Pautu, is there. Where is Mr. Pautu? I have seen him in court 1. He may be there, but this is a statutory appeal.
Statutory appeal, my
I'll
lord.
admit it.
My lord.
Heard Mr. L. Pautu, learned legal aid counsel for the appellant, and Mr. Thiang Liama, learned legal aid counsel for respondent. For the respondent. Stop. This is this appeal is preferred under Section 17 of the Mizoram Civil Courts Act 2005, read with Section 96 and Order 41 of CPC 1908, presented against the impugned order dated 4/4/2024, passed by the Additional District Session Judge, Champai Judicial District in Guardianship Certificate Application number 16 of 2023. Stop. Admit, issue notice, returnable 2 weeks. Since Mr. So-and-so accepts notice on behalf of the respondent, no formal notice required. You need extra copy?
My lord, I have not been served a copy of the memo of appeal, my lord.
Extra copies to be served within a period of 3 days from today. Call for the records from the Additional District Session Judge, Champai. List after, make it 4 weeks. 4 weeks.
Oblige,
You inform Mr. Pautu.
my lord.
Item number 12.
Yes, is the counter filed?
Your Lordship, a week time may be granted to file the counter affidavit. Your Lordship.
Any objection?
No, my lord.
As prayed for by MS,
Lalnun Louis.
so-and-so learned counsel for the respondent, which is not opposed by the petitioner, list this matter after 3 weeks to enable
Lordship, may it please be fixed the date?
list this matter after 3 weeks. List this matter on such and such date to enable the respondent to file their return in the matter. Yes,
Mr.
date.
Your Lordship.
Give the date.
Oblige.
You got the date? Give the date.
3rd of October. Item number 13.
Why you get confused in giving dates? Huh? Yes, who is appearing in 13? Applicant?
My lord, today I'm appearing on behalf of the
Yes,
respondent
but
number.
where is the applicant? None appears for the applicant when called. Your name?
Mr. Rempuya.
So and so appear, and you are appearing for?
I'm appearing for respondent number 1, and Vakala Nama was also filed for the respondent number 2.
And submits that he has filed power on behalf of respondent number 1. 1, right?
Yes, my lord.
1.
And Vakala Nama was also filed for respondent number 2.
1 and 2. List after 2 weeks on a date to be fixed by the registry.
Item number 14.
May I please, your lordship,
Yes.
if I may submit the the decision of the Honorable Supreme Court and judgment of this Honorable Court with regard to mandatory provisions of law to be followed.
Yes. Inventory you said was not prepared. Correct?
It was prepared but not as per the rules.
Correct.
Look,
You are the owner, right? You are the owner?
the driver.
You are the
Driver
driver.
of the truck, your
The
lordship.
owner was granted bail by this court
My lord,
earlier.
my lord.
Correct?
Yes, yes, your lordship.
And before I go to this decision, your main ground was number 1, inventory not properly drawn.
Yeah, not properly as per the 2022 rules.
As per the 2020 rules. I think you had
My lord,
handed, one second, you
the
had
first-
handed over a copy. Yes, this is the narcotic, drugs and psychotropic substances rules 2022.
Right, your lordship.
All right. Second,
Which-
your
which-
argument is
Which was made as per the section 52A and
52A is violated according to you.
Yes,
Why you say 52A is violated? What is there?
because the rules made there under are violated. There are so many irregularities on the part of the
NDPS Act.
prosecutions.
All right.
Then starting from my first point, my lord.
Yes. Which one do you want to? Which
My lord, at the
which
outset,
decision you want this court to first look into?
the first one is Mangilal versus State of Madhya Pradesh. Decided
Okay,
Decided
Mangila.
on-
Yes. Paragraph.
relevant paragraph is paragraph 7, page number 5.
Yes. Please read.
To be noted, the aforesaid notification was in existence at the time of the commission of the offense alleged in the case on hand, stood repealed with effect from 23/12/2022. That is the date of publication of the rules that I am mentioning, my lord. In any case, notification issued in derogation of the powers conferred under subsection 1 of 52A NDNPS Act can never contradict the main provision, particularly subsection 2. However, any guideline issued by the way of notification in consonance with the section 52A of NDNPS Act has to be followed mandatorily.
Yes.
This is the decision that I'm intending to rely upon, your lordship.
Yes.
It says the rules made it under also
Has to be followed mandatory.
Right.
Yes. Then
Then this Honorable Court Order 8/4/2022 in Sumen.
Yes, I have it. Paragraph.
My lord, in this case, the conviction was set aside by this Honorable Court.
Paragraph.
My lord, this is paragraph 16. This is a bit different because drawing of sample was not done before the magistrate.
This is
But
a
what the decision
non-compliance.
is
It
non-compliance
says
of the-
non-compliance raises a doubt.
Yes, right. And contradiction is there in the prosecution evidence.
Next.
Next is the recent judgment of the Honorable Supreme Court dated 13/8/2024.
Paragraph.
Paragraph is 21, the last page.
This is on bail.
This is on bail.
What is the offense involved in this case?
This is,
Unlawful Activities Prevention Act.
my lord,
Yes.
the decision, the relevant part
Yes.
is at paragraph number 21. The Honorable Supreme Court has
Paragraph.
said that
Paragraph.
21.
Mr. Counsel, paragraph 21 page is missing in the photocopy that you had handed over. It's not complete. Please give me a complete photocopy, please.
Yes, this one. I have highlighted the relevant portion here.
Yes, please read.
Before we part with the judgment, we must mention here that the Special Court and the High Court did not consider the material in the charge sheet objectively. Perhaps the focus was more on the activities of PFI, and therefore the appellant's case could not be properly appreciated. When the case is made out for grant of bail, the court should not have any hesitation in granting bail. The allegation of the prosecution may be very serious, but the duty of the court is to consider the facts, consider the case for grant of bail in accordance with the law. Bail is the rule, and jail
What is
is
the
an exception is a
what is
settled
the
law.
grams of the contraband article seized? What is the weight? How much?
Pardon, my lord.
What is the quantity of the contraband article seized in this case? Ms. Linda? Quantity?
In this particular case, my lord.
In the present case?
1.026 kg. 1.026.
1.046
26
26
kg of
kgs. Yes. Anything else?
My lord, if I may reiterate my
No,
grounds,
no more reiteration.
the rules that have not been followed.
All right. Yes, Miss Linda.
Form number 1.
Sorry.
Form 1 was not used. Rule 5.1.
Rule 5.1.
Rule 5.1.
Yes.
Then Rule 5.2
Yes.
is also violated.
Yes. And 7, I think.
And Rule 5.3 also.
5.3. Yes.
Rule 8.1.
8.1.
Rule 8.1 is violated. And Rule 13 violated. And and there is also violation of the section itself, 52A2. 52A subsection 2.
Yes.
Then next is Rule 18. Rule 14.
Rule?
Rule 14, 1-4.
Yes.
Then the next is section 57 is violated. Section 57 of the Act is violated. And the last one, my lord, with regard to non-compliance of the Act and rules, The charge sheet does not contain any disposal certificates.
Does not contain
Disposal certificate of the
disposal.
disposal certificate of the seized drugs, which is in violation of section 52 subsection 4 and rule 27(2) of the 2022 rules.
Which rule?
Rule 27 sub rule 2 of the rules that I have mentioned. So due to violation of these mandatory rules and law, there is no likelihood of conviction of the present petitioner.
All right.
Then, in his own case, as Your Lordship has earlier pointed out, in the statement recorded under 161 CRPC also, he denied that having that contraband drugs. He stated that he was just driving the truck and the contraband drugs, alleged drugs was recovered from it.
Yes.
Then the with regard to the owner, Your Lordship,
With regard to
the owner who has been released, he also stated, but my Lord, Your Lordship is well aware of the fact that 161 CRPC is not to be used as prosecution evidence, despite the fact that the co-accused has said that he was just implicated by the present petitioner. So on that ground, this Honorable Court has granted him bail. Then they are from the same village, Moor village. They are on the same footing. Then one more thing I would like to appraise this Honorable Court is that from the arrest memo of both the accused, the co-accused was, his occupation was recorded by the police
how
as
is
drug
all that
trafficker,
relevant that for consideration of bail, Mr.
and the present
Counsel?
petitioner is
You have argued
a
all this,
driver.
now don't reiterate the same points. I
my
I
lord.
think today we had fixed it for these rules which you have given.
My lord. So those are my submissions
All right,
because
noted.
of non-compliance of the mandatory
right.
provision.
Yes, Miss Linda?
My lord, the last court date, I was supposed to produce a case diary, but I have been informed that since the police station, they do not have resources. They, after filing charge sheet, they all submitted the case diary in the court. So nothing remains in the police station. If we want to produce a
Then
case diary,
we'll have to
call
call
the
it.
reports.
Why did you not say it in the beginning, Miss Linda? So much judicial time I have given to this matter.
My lord,
You
it
could have
may
said
not-
it in the beginning because you see so many procedural violations they are saying it. Now,
My lord, yeah, with
may-
regard to that,
one way this court could is that the court can say that these are things which has to be looked into the trial, but be that as it may, stakes are involved. It's the liberty of a person that is involved. Now, if these procedural requirements which are mandatory and have not been followed, then of course the discretion can be exercised in a different manner.
my lord, with regard to that, let me submit that maybe it was not followed. The rules of 2022 was not followed. But my lord, there is not the reason for granting bail. That is what I wanted to submit.
I'm posting this matter on Monday. By then, we will direct the
Registry.
scan copies of the
Case diary.
Case
The case
diary,
diary,
isn't it? It has to be produced from which court?
From the
Special court.
special court,
Special court.
Aizawl.
So Monday it can
Yes.
be,
Yes, madam.
isn't it?
About the entire charge sheet I have submitted before this Honorable Court.
It appears that it appears that non-compliance of the rules contained in narcotic drugs and psychotropic substances within brackets seizure, storage, sampling and disposal rules 2022 is being argued by the petitioner. Stop. Further, various other non-compliances of the provisions of the NDPS Act so and so is also being submitted by the petitioner. Before proceeding to consider the grant of bail, this court deems necessary to have a look of the case diary to satisfy whether such procedural requirements were followed or not. Stop. Accordingly, let the case diary be produced from the court of
Special Court NDNPS.
Special
Special Court
Special
NDNPS
Court.
Act Aizol.
NDPS
Right, Your Lordship.
Aizol.
Yes.
List again on Monday is a holiday, Wednesday?
Tuesday, Your Lordship.
Tuesday.
Oblige, Your Lordship.
Item number 15.
My lord, this is an appeal filed by the state.
Linda, you
Yes.
shifted the side.
Yes, madam.
Yes, you are the applicant.
Applicant in.
743 days.
Yes, madam.
Yes, you are.
Yes, Lordship, I'm appearing on behalf of the respondents.
Any objection?
Yes, my lord. Yes, my lord.
Have you filed any objection?
As I've just received instructions from my colleague who is stationed in Lunglei.
You want to
So-
file it?
Yes, yes, Lordship.
All right.
All right.
As prayed for by Mr.
El Anunciama.
So and so, learned counsel for the respondent lists this matter after 2 weeks to enable the respondent to file their objection in the condonation application. List on such and such date. Give a date.
Obliged.
30th of September. For hearing. Item number 16.
Did you get the Talapatra judgment?
It's fine, right? And there is a file which has been married and all the acts together.
Yes, Mr. Joseph, this is that matter.
This is that matter, my lord. So in terms of judgments, my lord, I have not been able to find new judgments. So
There is
that-
a judgment of Justice Talapatra. Have you got that?
which one is this? Which year is this, my lord?
I am not sure of the year, but it had also reached the apex court. But then I think there was some compromise, and ultimately the decision of this court was not touched. But it is of Justice Talapatra where the heirship things and everything had come up.
Okay. So how was it mentioned, my lord? I'll look into this judgment also, my lord.
Anyway, what have you found?
So what I have found, my lord, the first thing is with respect to heirship and ownership, my lord. What I have seen is, I'm not sure how relevant this would be, but my lord, if I will read out, my lord, this is from the new Act of 2014. It says like this, my lord. This is section
Is
23.
this Dr. HTC's book?
This is HTC's book. It's compiled. It's a compilation of his.
I think I have it. One second. This
Yes,
is
yes, yes,
getting
yes,
my
yes, yes.
There was a file, no? There is that book he's holding. Is also.
But if it's the same,
Please get that also. Yes, page.
now page 81, my lord.
Yes.
Lordship, at section 23.
Yes.
Now, what it says is ownership right of head of family over properties.
Yes.
Now, what it says, my lord, all movable and immovable properties inherited and acquired, which is not registered in the name of any member of the family living under the same roof, are deemed to be the property of the head of the family. Now, the reason I'm stressing this, my lord, is because this is one area where I can see ownership and inheritance being
Once
used
you have
synonymously.
a heirship certificate,
Yes,
you will be deemed to be the owner.
correct.
So
That is one.
means your ownership is decided.
Correct. That is one aspect, my lord. And if your lordship will see Rule 24.
This provision is under which act?
This is 2014, my lord.
This is the
14.
2014 act. Now, but this act is not applicable in your case.
It was not relevant. It was not there in my time, my lord. But
because Mr. Joseph, something very interesting that I have noticed.
yes, my lord.
The heirship concept
Yes.
prior to 2013 doesn't exist anywhere.
No. Yes. In law,
I
it
have
was
not
not
seen.
there.
I have not seen anywhere.
Correct.
Your those inheritance act is of will, probate.
Yes.
It doesn't talk about inheritance.
Let's not talk about.
From where did this concept of heirship certificate come? And in 2013, that act also, there is a form,
Yes.
but there is nothing.
There's nothing.
The procedure, nothing is given.
Exactly.
Simply a form.
It is basic.
There is no backbone.
There is no backbone. It is basically.
Can then these proceedings be said to be legal? From where has these concept come up? Your customary law also, I don't find anywhere saying that a heirship certificate has to be applied, how a heirship proceeding will go on. Nothing, nowhere I'm finding. Correct me if I'm wrong, but I have done some research last few days. I can't find anything.
It is almost like, let's put it this way, my lord. Let me try and understand it, put it this way. It's almost like a common law concept where there is no written law as such, but out of practice, it has become evolved into a law. So because of this reason, my lord, cases have gone up to the
But be
Supreme
that
Court.
as it may, it appears ownership is
Correct. That is what I am
decided.
saying, yes.
This is what you are trying to
This is
show,
what I'm trying
right?
to say. It is an, yes. And
It
yes,
appears
Yes.
that ownership is decided.
it's decided.
Is decided.
And my lord, I would like your lordship to keep this in mind also. If your lordship will refer to the Mizo District Land and Revenue Act 1956. This is with respect to, my lord, mutation and also with respect to allotment of land.
Which act? Which act?
This is the Mizo District Land and Revenue Act 1956. If your lordship has this book, my lord, it is there in this book
The
also.
first book, yes. Volume 1.
Yes, this is the second. my
Volume
lord.
2.
This
LC. Volume
this
2
this
is
one you
also
have.
get it. Volume 2, next to the phone.
second edition, my lord.
This handbook appears to be very helpful.
Yes. It has all the compilations.
Yes. Credit goes to the registrar.
Yes.
Page.
Now, my lord, at page 15, I'll first take a look.
1.5.
1.5, my lord.
Yes.
At page 15, the settlement holder, my lord, definition clause.
Yes.
Settlement holder means any person
Page
other
15.
than. My lord has got it at page 15. Is it at page 15? Not the Roman page, my lord. Is it the same book, my lord? I'm not sure.
This is this volume 2. No, I think what you are holding is a different.
Okay, my lord, my lord has the Mizo District Land and Revenue Act.
Wait,
Mizo
I
District
think it is part of that compilation the other day I handed over to you. I think it is that. Anyway, you are referring from the definition clause?
From the at page 4 of that one, at page 4, my lord, the one you had given me, lordship, at page 4.
Yes.
So at page 4, lordship will see rule 2 subclause 8. It says settlement
yes,
holder.
I've got it. Settlement holder. Yes.
Settlement holder means any person other than a pass holder who has entered into an agreement with the administrator to pay land revenue and is deemed to have acquired status of settlement holder under section 7.
Yes.
Now section 7, my lord, will come, page number 6. Settlement holder's right over land.
Yes.
The settlement holder shall have heritable and transferable right to use or own or of subletting in his land subject to A, payment of all revenue and taxes from time to time legally assessed or imposed in respect of the land, B, such terms and conditions as are expressed in his settlement lease and rules made thereunder. So settlement holder, my lord, more or less has this absolute right. You cannot say absolute completely, but more or less absolute right. One is to transfer and one is heritable. Now, how does a person become, my lord, a settlement holder? Now, in that respect, my lord, how does a person become a settlement holder? If your lordship will turn to rule number
12.
Rule number 10, my lord. Let's start from rule number
Alright.
10, my lord.
Recording.
Yes, recording and demarcation of land.
Yes.
The administrator or any officers appointed in its behalf shall survey all lands to be recorded. The demarcated boundary and the assessed revenue to be paid annually shall be recorded in the General Register vide Appendix A. The administrator may prescribe, subject to a paragraph 8(1) of the 6th schedule to the Constitution of India and to this regulation, principles on which the land revenue is to be assessed, the terms for which and the conditions on which settlement may be made. The settlement holder shall make proper boundary marks as may be directed by such officer or the administrator. Recording shall be made in such manner and after such enquiry as may be prescribed. Certificate of possession and assessment. A settlement holder shall, on the completion of survey and demarcation of boundary, obtain a certificate of recording. For the details of that land on payment of such amount of recording fee as may be prescribed, different rates of fees may be prescribed for any local areas of class of land. Local ownership. Possession of such certificates showing details of boundary, area and assessed revenue to be paid annually shall be deemed to be the conclusive proof that the land has been settled in with the holder of the certificate and that all rights and interest arising out of such settlement have vested in such holder of the certificate. If the settlement holder violates any terms of the lease shall be liable to be cancelled. So this is, my lord, how you become a settlement holder.
Yeah.
Now, if your lordship will come to the rules, does your lordship have the, I think your lordship will, it's there, the rules are there, my lord.
Yes. Mizo District Land Revenue Rules 1967.
Correct,
Yes.
my lord. Your lordship will come to rule number 3.
Rule number 4, I think, land settlement.
Rule settlement is chapter 2, my lord, but your lordship will come to rule number 3.
Rule number 3. Yes.
Power of executive committee. Let me just read this also, my lord.
Yes,
The
please.
executive committee shall be the chief controlling authority. The executive committee or any officer appointed by it in writing in this behalf may dispose of vacant land and the land under pass or permit by granting settlement or periodical leave as prescribed by these rules, provided that the executive committee or officer appointed in this behalf shall have the power to reserve any vacant land from settlement. The executive committee may order any land under pass or permit to be settled under this act and under these rules. So the executive committee has the power to allot lands, suo motu also, my lord. That's the first one. Now the second one, my lord. I'll go to number 5, my lord. Number 5.
Application for land
Yes, correct. So it can go through suo motu or by application. Application for land settlement shall be in writing and presented to the executive member in charge, land settlement, or to the officer appointed in this behalf if the executive committee orders under Rule 3 and land pass or permit to be settled, no such written application will be necessary. So if it goes under Rule 3, no application necessary. Rule 5, you have the application, my lord. And then after the application, my lord, Rule 6 comes in. On receipt of an application, the executive member of the officer shall cause the land to be surveyed, measured, and demarcated unless he sees reasons to reject the application summarily. A sketch map showing the length and breadth in feet, the area of the land in square feet and in bighas, and the boundary description of the land shall be made in the survey and submitted. The executive member or officer shall also ascertain whether the land applied is available for settlement and free from encumbrances. The executive committee may order summary survey if deemed necessary for settlement subject to revision. In such case, the executive committee may prescribe in writing the manner for which summary survey. Now, disposal of application. After
That's
receiving,
all right.
So, my lord, the first aspect, let me just explain, my lord. In order to become settlement holder, application is there, survey is there, and then you become the settlement holder.
Registration.
Registration. Now, my lord, mutation
21.
is the next step. This is what I wanted to explain, my lord. Mutation, if your lordship will come to the act, again, my lord, section number 14.
Section 14.
Yes, my lord.
Periodically? No.
Section 14, my lord, your lordship has got it. No transfer of any right. Lordship at page number.
Sorry, one second. Yes. Transfer of ownership.
Correct.
Yes.
Transfer of ownership. No transfer of any right, title, or interest in any land shall be recognized by the administrator or the village council, and no person shall be deemed to be exonerated from any liability due to the administrator or the village council by virtue of such transfer, unless such transfer is registered in the office of the administrator in the manner prescribed.
And
So this is
Rule 21.
Rule 21. Your lordship will come to Rule 21. At Rule 21, it says,
When any settlement is granted under Rule 7,
7, 14, and 15 of these rules, the same shall be entered in the general register. This is mutation, my lord. This is aspect. Lordship will come to Rule 25, transfer of land.
before that, I think 22 is also important on completion of registration.
Registration, a certificate of land settlement.
This is the that LSC which we keep referring.
This is the LSC which we kept referring.
Yes.
This comes after application is made, my lord.
And this is held to be hereditary and transferable.
Transferable. But now the next step is transfer, my lord. Lordship will come to 25.
Down.
Transfer of land.
There is some problem here. This is rule number
25, my lord.
25. Okay. Please read.
I'll read, my lord. If a settlement holder or a lessee wants to transfer his land partly or wholly to another person or body, he shall apply for the same. So I have to apply, my lord. The LSC holder has to make an application for transferring. And if nothing is found against his doing so in the terms and conditions of his certificate, the same shall be effected in the register and in the certificate on payment of mutation fee of ₹10. If the transfer of land is in part and requires new certificate, the person to whom the new certificate is to be issued shall pay registration fee of ₹10 and certificate fee of ₹5 under rules 21 and 22 in addition to the mutation. This for the first time, my lord, mutation is used here. To the mutation fee paid by the former settlement holder. In the case of transfer of land from a tribal to a non-tribal, and from a non-tribal to another non-tribal, the relevant provisions of Mizo district. This part is not relevant. So, my lord, what I'm trying to say, firstly, if you are the original LSC holder, you have more or less absolute ownership. Now, the second stage comes when it comes to transferring and mutation, my lord. In that case, there has to be a proper procedure followed, my lord, mutation. And I'm referring to this because, my lord, the Supreme Court judgment makes complete sense when we look at it from this perspective, my lord. Mere mutation.
Predecessor's interest has to be
Correct.
looked into.
And mere mutation, my lord, does not give you ownership and title. Even in Mizoram, my lord, it has to be, because mutation is the second step. And I think in the 2013 Act also, my lord, the new Act, the Revenue Act 2013 also, this same kind of procedure is there. First is that allotment, and the second step of transfer and mutation.
Which one?
The 2013 Act, my lord.
All right.
2000 Mizoram Land Revenue Act 2013.
Yes.
And in that, the system is more or less the same, my lord. So I'll not take your lordship through all of those Mizoram 2000.
Mizo marriage, divorce, inheritance or property?
No. But the Mizoram Land Revenue Act 2013. Let me see if I have an extra copy, my lord.
No, I should be having. There are so many books. Is it there in these compilations?
It should be there in this, my lord. Mizoram, in the land laws, 2013 Act, Mizoram Land Revenue Act 2013.
Mizoram
Land Revenue Act 2013. One second. If it is here, it will be better.
Okay. This is
Yes.
Section?
Section 2, subclause 3, Lordship will come.
Section 2.
Section 2, subclause 3, my lord. Definition clause 3.
Subclause
3, my lord.
3.
Yes.
Allotment.
Allotment. So it has a special separate definition on allotment.
Yes.
Allotment means allocation or apportionment of land or part of it to a specific person or body of persons having legal entity known as the allottee by the state government or the competent authority in this behalf, my lord. That is the allotment. And Rule 11, my lord.
Yes. Certificate of land settlement.
Correct. Or land settlement certificate means a certificate granted under Section 11 of the Mysore District Land and Revenue Act.
However,
19...
this act otherwise shall not apply to the facts
No,
of
it does
this
not
case,
apply in
right?
this present case. But in what I'm trying to say, my lord, the new act also has this two distinction: allotment, then after that transfer and mutation. These are two different concepts. So if you might be in the record of rights, my lord, but
That
if the
itself
mutation
will not be a recognition.
yes, because you have to look back into the original transfer.
Follow.
And also, my lord, here for the first time, heirship has been mentioned. This is what I want to
where?
point to your lordship also at section. This is one minute, my lord. I'm not sure if this is the rule or the act section. Okay, act section number 98, my lord.
98. Yes.
Transfer of ownership of land. So it goes on. If a settlement holder, so all of those things are mentioned, my lord. And if your lordship will come to, 1 minute, I'm sorry, not.
Because I found heirship only in that form to that marriage act.
Correct. That is also there, my lord. But in this rule, my lord, let me just check 1 minute. Okay. So, my lord, we'll come to page number 490, my lord. Sorry. In the rules, rule number 27.
Rule number?
27. Lordship has got it here.
Yes.
Rule number 27.
27. Mutation and partition.
Mutation and partition, my lord. And your lordship will come to the proviso number 2. Second proviso.
Yes.
Provided further that in case of transfer by way of partition or by acquisition of land or gift or exchange, the original landholder shall have to pay the amount of processing
One
fee.
second. Why it is not here? Where is the proviso?
My lord,
This reads as mutation and partition, correct?
and then there is section subclause 1.
Subclause 1, then
Subclause 2 is there.
2.
Then lordship will see immediately below proviso is there, provided.
There are two provisos.
Yes, the second proviso, my lord.
Okay, I've got it.
Provided further that in case of transfer by way of partition or by acquisition of land or gift or exchange, the original landholder shall have to pay the amount of processing fee as stated in the first proviso except by inheritance. So for the first time here also inheritance is used.
Now explanation says heirship for the purpose of this rule.
For the purpose of this rule, inheritance is permissible only on submission of heirship certificate. So this is the first time, my lord. Before that act, there was something called heirship certificate. So it has been recognized by these actors.
First time it appears.
Yes.
In the body of a rule.
Yes.
Besides a form.
Besides a form.
But this is 14.
This rule is 2013. So the act was 2014, my lord.
The rule. How come the rules are 13?
No, because I think the act also is 13, my lord. Lordship, this is the revenue rule.
Yes, 13.
Yes, both of them 13. The first one came into effect on 1st May. The act came into effect on 1st May.
This shows that inheritance is permissible only on submission of heirship certificate.
Yes.
So this is from where you appear that an heirship certificate is required.
Yes, and so that's why more or less, my lord, what I have seen is the trend is to equate ownership with inheritance.
All right. Grateful. Yes.
My lord, with regard to the proceeding under heirship certificate, my contention is that what the court has to see under the application of heirship certificate is with regard to the entitlement of the petitioner, whether she or he is entitled to inherit that particular property. Because at the time of applying the heirship certificate, that particular property is already in the name of the husband. My lord, I have perused one of the copy that was supplied by your lordship. That was decided in the case of the
Which one? Probate one or
that succession.
succession?
But your lordship is true with regard to the non-availability of specific provision with regard to the heirship certificate. We are following the principle of justice, equity, and good conscience.
That is okay.
And-
Therefore, what was my the query put to you both was the nature of these heirship proceedings.
My
Now,
lord.
some light has been thrown by Mr. Joseph by referring to those relevant acts and rules. Now, from that Land Revenue Act also, it appears that the land settlement holder has a hereditary and transferable right, correct?
That is correct.
Now, therefore, so once the land settlement holder expires, then what happens? The inheritance comes in, correct?
My lord.
Now, in order to claim inheritance, what do you have to show? The heirship certificate,
Exactly, my lord.
correct? So, if you look into all this, it appears that the ownership has some relevance, because if the land settlement holder is not the rightful owner, then the question of consequent questions of inheritance and all will not come. Suppose that land settlement holder's right itself has been disputed in a heirship certificate proceedings. Would it not then be imperative for the court to adjudicate the issue? Because ultimately the entire issue has to be put to rest. Because here it appears it is not a mere recognition. Heirship is not a mere recognition. Heirship also appears to be deciding the ownership.
Yes.
If you look into it from these acts and rules,
Yes, my lord.
isn't it? Because you see this act section.
My lord, in that regard, I'd like to bring your lordship to, I'd like to refer the decision which was already made. I have the copy here.
Yes. Which is that decision? The one which I had given.
No, my lord.
Another.
That is the case of Raliani and Kite versus Kite Tuami,
Yes.
which is decided, which was already decided by the this honorable court.
No, but this decision I think has been overruled.
It's overruled, but overruled in the sense, what I'd like to show your lordship is
Yes, I have seen
the
this.
principle which was
No,
reflected in the.
I have seen here, because here I think it says somewhere it mentioned.
What can be seen is, my lord, in that regard, the at para 5, your lordship, if your lordship may kindly see, para 5
Yes.
of the judgment, the para is like this, my lord.
Yes, please read.
The application of Kite Tuami claiming heirship certificate in respect of the properties in suit of her husband was initially registered as heirship certificate number 1275 of 1996, but after receipt of objection from Srimati Raliani and her two daughters, the case was converted into civil suit number 13 of
This is what I am
1996.
saying. Here it should have been converted into a civil suit.
Yes,
The moment it gets converted into a civil suit, and if that objection is there,
yes,
here we have noticed that they have objected, but then the court did not give them any permission, did not give them any opportunity to file a WS. You see, where is your plaint? There is no plaint also. There are no pleadings. The moment it gets converted into a civil suit, what will happen?
yes. If
Provisions
in-
of CPC in spirit must have come, because those days CPC perhaps was not applicable in such proceedings, correct?
my lord,
In this case, but the spirit of CPC will have applied. So they should have been, both parties should have been given an opportunity to adduce plead their cases and then adduce of evidence to prove, isn't it?
my lord.
That was not done.
That was not done, but my lord, during the relevant period, if there is an objection, it has to be converted into a civil suit
That
by
objection
deciding
I
all
find
those.
is there in that, in response to the advertisement, the translated copy, it appears that they said that we are astonished
Yes.
and how, but after that nothing happened. In fact, you filed a reply to a counterclaim. There is no counterclaim.
Still, my lord, in that regard, what I'm still asking is that, my lord, will it be appropriate to reconsider the matter under the nomenclature of the case as airship certificate? The avenue to be considered, the criteria to be considered is quite narrow, my lord.
It
With
has
regard-
narrowed down.
Yes. If we are to consider the legality of the mode of transfer of ownership from the name of the father to the son, so that has to be considered under a civil suit, my lord, not under the airship certificate.
Yes, that is why that proceeding should have been converted into a civil suit.
Yes, my
That was
lord.
not done.
That was not done.
That was not done. From the day one, I think I have
Yes,
saying
not
that,
done.
isn't it? Anyway, what is to be done? I think a little, a short note from both sides perhaps would be important, because it looks like I will have to reserve the judgment.
Yes.
So I can close it today, or otherwise I can post it on next Friday. By then you have sufficient time to prepare your written notes.
And we
Once you
submit it via-
submit it, however, I shall join through video conferencing mode.
Yes.
So you both will have to give a soft copy and also file a hard copy with my court master. Friday? Is Friday good?
Friday should be good, my lord.
List, hearing concluded. Parties to submit written submissions. List on such and such date, Friday. Part heard. Huh?
No, wait a second, my lord. This next week. I'm so sorry, my lord.
You have
I
some
might-
difficulty?
No. Yes. So if it's possible, the week after, my lord, because it
Anyway,
should be together.
there is no difficulty. Please give me a date. Both of you can give me a date when it's convenient.
My lord, on the 25th,
All right. 25th of, is it?
this month only, my lord.
Guwahati bench is open. Just check the calendar and then give the date. I'll see this everything together. Huh? Put it in my room. I'll just resume in 5 minutes. leftovers.
1 and 2.
Yes, in this item 1 and 2, my lord, after clarification, it appears that award has been passed.
Award has been passed.
My lord.
So then it's complied.
Complied.
I have furnished, Your Lordship, I have furnished the copy of the award, finalizing the acquisition proceeding.
Heard Mr. Lalfa Kwama, learned counsel for the petitioner. Stop. Also heard Mr. B. Lalramyanga, learned counsel for the respondent number 1, 3, 5, 8, 12, and 13.
My Lord.
Yes, anybody else? Are you appearing? No. There are a lot of names shown otherwise. Nobody
There are
else
quite
is
a number.
appearing.
Yes, Miss Mary is on maternity leave.
All right, all right.
Yesterday they appeared through online, my Lord, virtual.
She actually informed me last night that her baby is not doing well.
No problem. She's already submitted, so I can record her name.
I believe so, my lord.
You ask her if, and then inform. If she's appearing, then I'll put her name.
In fact, Your Lordship, the copy of the award which is presented today was provided to us by Miss Mary only.
Okay. There are so many orders. I can't find where the petition starts from. Where is the petition, Elsie? Why is it so in such manner? This petition is filed under Rule 9 of the Contempt of Court, Guwahati High Court, within bracket, Rules 1997, read with Section 11 and 12 of the Contempt of Court Act 1971 and Article 215 of the Constitution of India, bringing notice of the alleged non-implementation of the judgment and order dated 11/4/2018 passed by this Honorable Court in review petition number 2 of 2018 along with WPC number 123 of 2016. Stop. The operating portion of the order dated 10/7/2017
Page
is
20.
reproduced here under for ready reference. B2B at page 20. It is submitted at bar that the acquisition proceedings have been completed in terms of the aforesaid order. In support of the same, MS Mary, learned counsel, appearing for respondent number
15.
so and so, has submitted a copy of the award. This is the copy of the award.
Page 3 is the award, my Lord. Page 3.
Copy of the award, page.
Page 3. At the top of the page, right side, page number is given.
Copy of the award, which was forwarded to the Deputy Commissioner, Mamit District, Mamit, by the Under Secretary to the Government of Mizoram, Land Revenue and Settlement Department, by letter dated 15/11/2021. A copy of the said award along with the relevant correspondences handed over to the court is kept on record. Apparent that the order of this court dated so and so stands complied. Accordingly, nothing survives for adjudication in the instant contempt petitions. As such, the contempt petitions stands closed.
My lord, if I may, your lordship had dictated certain orders yesterday that my submission would be incorporated in the final order.
I will just check that.
Yes, your
I will
lordship.
check that.
Just that.
I think I have dictated something.
Yes, your
You were
lordship.
there or Marshwai was there? Just give me that order. I will just check that.
If
Okay.
my submission can be
All right,
reflected.
all right. I will check
And also, my lord, that you will not prejudice the rights of the petitioners to seek such remedy as may be available under
Mr.
law.
Lalfa Kwama, where is
I'm not
the
seeking
question
liberty,
of
just
any
to mention that.
prejudice? This is a contempt petition. You have your remedies. If you are aggrieved, you don't need any leave or liberty from this
I'm
court.
not seeking leave or liberty. If that
Anyway,
may be reflected.
that
my lord.
part where
That may be
the
reflected, yes.
submissions have been recorded, I'll incorporate that in this order.
Very well, my lord.
All right. Both the contempt petitions are same, isn't it?
It's the same, just that the judgment date and the WPC number will be slightly different. Otherwise, everything is the same.
Can you just write down the WPC number and the judgment date and give it to my court master?
Very well,
Just
my lord.
that part.
For the item number 2.
Item number 2.
Very well, my lord.
Both disposed of, huh? Both closed.
Highly obliged, man.
Thank you.
Item number 4 to 10.
Yes, Mr. Jordan.
Your Lordships, I'm appearing for the petitioners in item 4 and item 10.
Some
My lord-
AO was supposed to be filed by respondent number 5.
Yes.
Who is appearing for respondent number 5?
My
Ms.
lord.
Angpui?
For the respondent number 5.
What is the status of your AO?
My lord, I inquired the matter yesterday. Then the regional officer instructed me to pray one more chance.
All right.
Then for filing.
Mr. Jordan, any objection?
My lords, this matter had been filed sometime in February. Time is being taken, my lords, since then. My lords, more than 6 months.
We'll give them a last chance.
Last chance, my lords.
Yes, my lord.
My lords, similar direction, my lords, be issued against, my lords, the state respondents, my lords. Till now, they're counted.
Two respondent numbers?
1, 2, 4, and 10, my lords.
1, 2.
1, 2, 4, and 10, my lords. These are the state respondents.
So I'll say state respondents.
Yes, my lords. My lords
Who is
respond.
appearing for the state?
Yes, I'm appearing.
What about your return? When do you plan to file?
Yes, my lord, if we may be given another 2 weeks' time.
By now you should have filed it. You're not even praying. You are simply standing under the shadow of the CGC.
No, my lord, actually I'm appearing on behalf of Miss Mary.
That's okay, but you'll have to make a prayer if you want to file something. The court has to ask you. How much time, Miss Angpui, how much time do you
My
need?
lord, at least 3 weeks' time.
3 weeks?
Yes, my
Is
lord.
this going to be your last chance?
Yes, my lord.
Yes, my lord, I will inform
If you
her.
want to file something, file it by the next date of listing. No further chances for filing counters would be given to anyone. Miss Sangpui, Learned CGC. You're appearing as CGC, right?
Yes, my
Learned
lord.
CGC for respondent number
Number
5 seeks further 3 weeks time to file return in the matter. Mr. Jordan, so and so learned counsel for the petitioner highly objects to the said prayer as on sufficient number of times as sufficient time has been already given to the learned CGC to file their return in the matter. Stop. Be that as it may, this court, by way of a last chance, grants MS Sangpui learned CGC to file the return by the next date of listing. In the meantime, the other state respondents, if desired, may file their return as well. It is need list the matter on, yes, after 3 weeks, give a date on such and such date. It is needless to clarify that if on the next date of listing returns are not filed by the respondents, the matter shall be proceeded on the basis proceeded in accordance with law. Stop. Mr. Samuel, you're appearing?
My lord, 25 October.
25, okay. 2510. Mr. Samuel?
On behalf of the respondent 6 to 9, we have already filed, my lord, in
Uh,
IDC.
on top you say, Mr. Samuel so-and-so, learned counsel, appearing for respondent number
6 to 9.
6 to 9, however, submits that the said respondents have already filed a return in the matter.
My lords, we filed a rejoinder too.
Mr. Jordan so-and-so seeks 2 weeks' time to file
No, my lords, we filed.
and it appears that rejoinder to the said affidavit has also been filed.
My lords, if I may, my lords, add one thing, my lords. A respondent number 3, my lords, who is the competent authority, my lords, notice has been issued. Service has been complete, my lords, as per records.
No one is
But
appearing.
no one is appearing, my lords.
Is there any judicial order saying that service is completed?
My
again?
lords,
yes, it's there.
yes, it is there.
Though, I'll also add, though it appears that notice upon the respondent number 3 is complete as per the order of this court dated 3/6/2024, however, none appears for respondent number 3 today when the matter has been called.
Grateful, my lords.
For hearing, item number 17.
Please, Your Lordship, my Lord, as per last order passed by this honorable court, copy of writ petition.
Some additional affidavit was required to be filed. Mr. Lalram Tlwanga, learned counsel for petitioner, shall bring on record
Yes.
orders passed by this court in the proceedings instituted by the petitioner herein, preceding the present proceeding. Where is it?
WPC
Judicial
number.
order is to bring it on record. You don't bring on record by passing.
Affidavit.
File an affidavit.
My Lord, yeah.
Mr. Lalram Tlwanga,
Yes.
learned counsel for the petitioner, submits the judgment and order dated 28/6/2016, passed in WPC number 93 of 2015, WPC number 38 of 2013, and WPC number 43 of 2013. Stop. However, it appears that by order dated 29/8/2024, the petitioner was directed to bring on record the orders passed by this court in the proceedings instituted by the petitioner herein preceding the present proceeding. Stop. Let the said judgment and order dated 28/6/2016
My Lord,
be
23,
placed-
23 order also is there.
Huh?
23 order is also there. WPC 24 of 2018.
Let the efforts, let the said orders be placed through by way of an affidavit before the next date of
My Lord,
listing.
that 2018 order is also there.
This pink flag, there is another order.
It is flag.
It will be done. How much time you want?
Weeks.
2 weeks.
My Lord,
Give a date after 2 weeks. List on such and such date.
my Lord.
26 September.
Yes.
My Lord, Your Lordship, before part 2 item, with apologies, Your Lordship, if I'm allowed to make a mention regarding item 12 of part 2 list, this may come up tomorrow, my Lord, because today,
Tomorrow.
yes, I have personal difficulties today.
Tomorrow, I'm not sure if there will be time,
Or-
but let's try.
Yes, Your Lordship.
Or you want it next week?
Next week, Monday, my Lord, if my learned friend again, please.
In item 12, list as prayed for, list again next week on a date to be fixed by the registry.
If possible, for item 14 as well. I'd
Also same order for 14.
deeply obliged.
Yes.
Much obliged.
Part 2, item number 4.
My lord, this is the MAC appeal. I think the LCR will be required.
It's not there.
Evidences have to be looked at.
LCR is come, you have a look, I'll have it reposted. You have a look at the case records. Mr. Silo?
Lord, I have some of the cases.
So then you have, because since some LCR, get me the LCR. Get me the case record.
I think we can proceed, Your Lordship, if Your Lordship.
All right, we'll make an attempt. Only thing is that this bench is only available for tomorrow, and then I don't know when next I'll be available here.
Lordship.
That is the only difficulty. How much time will you all take?
I have several grounds of appeal, Your Lordship, and we will have to go through the evidences and the annexures.
So it will take some time,
It will take some time.
because if I cannot finish the hearing, then there will be no point of
It's up to Your Lordship.
starting.
It's up to Your Lordship. Let's see if,
How many evidence?
quite a few.
Quite a few. Then have it next week.
Those are only- just for the past day.
Lordship will not be present in the next week, Lordship.
And I'll be holding court in the principal bench. So if you are going to finish it today, tomorrow I'm here. So if you are finishing it, then I can start with the hearing.
12:31. Lordship, it's 12:31 only. So let's make an attempt.
All right.
If my learned friend doesn't insist.
All right.
Lordship is willing, I'm always ready.
All right, Mr. Silo.
If you please, Your Lordship.
One second.
Just a minute.
Yes.
Your Lordship, I have item number 5.
Yes.
This is civil matters also. I heard that yesterday my opposite party mentioned, it seems, that
Yes.
even though you have mentioned in the first hour that we will be having today. I don't know. I have not
They did
seen
not.
the
They didn't take your consent yesterday.
They have I don't know, without my knowledge, he came here again in the afternoon and mentioned it again, it seems.
When do you want this matter?
I want it today, but it seems it's
They are not
impossible. They are not there also.
All right, I will then direct it. Give me a date next week.
Your Lordship, since the appellant is not present, and this may be taken up after holiday, since I may be out of station.
Then you do one thing.
Yes.
You get hold of the appellant's counsel.
Yeah, I just call him
And
up.
be here tomorrow at 10:30. Because this list is valid also for tomorrow. Otherwise, one day they come, the other day
Right,
you come.
right. I
So it's
know.
better you both come together.
I inform her, and
You be here
he
together?
won't be available tomorrow also.
He will not be available.
Yes.
Ask some junior of the council to be here, because when both councils are not there, it's very difficult.
Yes.
Now you have come and
I
said,
just informed him today
all right.
itself,
If
and
you
I
both agree on
yeah.
a particular
We are
date,
agree
on a particular
Yes.
date, then I shall fix
after
it on that.
after holiday.
You first you get hold of him.
I have already informed this morning. If you are not come, can you fix the date in after holiday? He said yes.
Mr. Silo, it's very difficult. The other day they came. Now both are not here. Who is appearing for the other side? Who,
Alrin
for the appellant?
Lalomzwala.
Huh?
Alrin Lalomzwala.
Who?
Alrin.
Mr. Aldrin Lalwat. He doesn't have a junior?
No, so far as my knowledge, no.
Yeah,
Oh,
then
and then-
please, Miss Linda, please ask
Yeah,
your junior. Thank you. Because otherwise, unnecessary a controversy arises.
I already
All right. When he comes, I'll see, just take a consent date. Yes, Mr. Silo?
My lord, this MAG appeal is directed against the judgment and order of the MSCT, Aizol. The case is MSCT case number 55 of 2018. And
You are the insurance company.
I'm for the insurance company, the National Insurance. And my lord, in that case, the judgment and order was passed on 12/7/23.
Yes.
And my lord, this is a case where two vehicles dashed each other. The deceased, the claimant deceased, was driving a scooter. And the other vehicle involved in the accident was a Maxicab Sumo. And I'm the insurer of the Maxicab. So that is basically how it happened in Aizol itself. The accident took place. and they have filed a claim. And the claim was disposed by the said judgment and order, whereby the claimants were awarded 14 lakhs 3,880 with 7% per annum. And being aggrieved, we have come before this court, Your Lordship, and we have several grounds of our appeal. My Lord, if your Lord is ready, I will take you to the grounds, Your Lordship. So, my Lord, first of all is the maintainability of the claim itself.
Yes.
The claimants herein have approached the MST by filing their claim under Section 166 of the MV Act. 166 MV Act puts a burden on the claimant to prove that 166 of the Motor Vehicles Act,
yes,
1988.
Yes.
And if the law says that if you come to the claim, if you file a claim under 166, the burden of proving falls on the claimant to prove that the result of the accident occurred due to the negligence of the other vehicle, not the deceased vehicle.
Yes.
So that is the big hurdle they have to cross. So the burden's on them.
That the negligent is on
caused by another person.
Another person.
Like another vehicle had dashed me, or I was within my right.
Okay.
So they have to prove that. And that is on that point, my Lord, we have stated that the police officer who has done the inquiry, if we go through his report, it will be clear, Your Lordship. So in the claim form, my Lord, if I take Your Lordship to the claim form.
You are Mr. Benjamin.
No, sir. No.
You are for the claimant.
I'm for the claimants.
Lord, there's an annexure 11 in the claim form, which is the report of the officer who has conducted the inquiry in the case.
Statutory deposits have been done.
Has been done, Your Lordship.
Yes.
So, my Lord, if you see the page is not written here.
No, where are you reading from? From
the claim petition, from the LCR, Your Lordship,
I try to refrain myself from referring the trial court as lower courts.
My Lord.
Because they are not lower.
Correct, Your Lordship.
I keep correcting myself. Even sometime it comes out because I'm adopting to that change.
And my Lord, that on that ground, we should not have said LCR anymore.
No more. So
trial court reports.
Generally I say TCR.
Yeah.
TCR, trial court records, or simply case records.
Yes, case records.
This is something which during a function of the Guwahati High Court relating to the to one of their function, the CJI had mentioned.
Right. Yeah, I remember that. Maybe that's the Chief Justice can take up with the Chief Justice.
No, it's all right. We should adopt to all these changes. We should not refer them as lower or subordinate courts. They are not lower or subordinate.
But in the cost list, in the Guwahati cost list, every time is within LCR.
Yes, that is why I'm saying we have to bring this change.
Yes. Correct, Your Lordship.
We have to bring it, Mr. Silo.
Correct.
Yes.
So, my Lord, if you'll see the claim form, they have put on the first page, you'll see lots of photographs, passport size photographs.
Yes.
This is the claim form which has been adopted.
So this is the form.
Yes, the form.
This is page 1.
Page 1, I think.
Yes.
And if I take Your Lordship to...
So the claimant is one Zobela.
No, there are 6 claimants. That is the next point, my Lord. We'll come to the next point.
Okay.
So first of all, regarding the accident itself, if I take Your Lordship to Annexure 11, the heading is Final Report of ISOL PS UD case so-and-so.
Final report, yes. Annexure 11.
Yes, my Lord. This is the uninterested person who have conducted the inquiry of the accident. And, my Lord, should I read, Your Lordship? Yes. The story of the case in brief is that on the morning of 25th 8, 2018, a telephone information received at ISOL PS from an unknown caller stating that there had been an accident involving one maxicab and one scooter where the rider of the scooter and the pillion rider sustained injuries near Old New Life Hospital at 5 a.m. in the morning. On receipt of the information, self and party rushed to inquire into the matter. The scooter rider and the pillion rider were immediately evacuated to civil hospital, Aizawl, for medical treatment, where the scooter rider succumbed to his injuries while on the way and declared him both dead at the hospital. On inquiry, it was found that one maxicab bearing number so-and-so Tata Sumo, driven by J. Zonun Sanga, son of so-and-so, was hit by one, so here, my lord, the Sumo was hit by one scooter bearing number so-and-so, driven by an unidentified male with one female pillion rider coming from the opposite direction towards Zarkot side. The pedestrian who witnessed the mishap had reported that while the maxicab coming from the northern side and one taxi from the southern side passed each other, this part is important, while two vehicles passed each other, northern side and one taxi from the southern side passed each other, one scooter coming from the south side appeared suddenly at a very high speed as if trying to overtake the taxi, thus hit the oncoming maxicab from the north side and fell on the ground. Both the scooter rider and the pillion rider...
Claimants were in the maxicab?
No, the scooter. So here is the scooter rider who has come at a very high speed, while two vehicles were
So
passing
you
each
mean
other.
to say the claimant came in the high speed?
The deceased itself is negligent.
That's what you're trying to do, right?
Yes. So, so it's from here, my lord, if I just pause, while the maxicab and another taxi, a third taxi, were passing each other on the curved road, the scooter out of nowhere, the rider who was later identified as Lal Matswana, age 29, succumbed to his injuries on the way. However, a female pillion rider identified herself as Lal Chanjimi Aizawl was admitted at the hospital. On later diagnosis, it was found that she had suffered multiple bone fractures on her person. Now, that part is important. On inquiry, it was found that the cause of accident was due to...
So how many persons were involved? One person died.
One person, the driver of the scooter died.
Driver died.
And the scooter had two occupants.
Scooter had two occupants?
Yes. One lady, Lal Machwani, was sitting on the back of the rider.
Pillion.
Yeah, pillion. Right?
And
the sumo, driver of the sumo. J. Zonun Sang is the driver of the maxicab.
Okay, maxicab.
Yes. So, my lord, the second last paragraph is important. On inquiry...
And Mr. Benjamin, you are for the...
Claimants.
For the son of the deceased.
Father of the deceased.
Father, mother, and the sisters of the deceased.
Basically for the deceased
for
family.
the deceased
family.
Okay. Anybody for the injured and the driver of the... They have not. Okay. Yes.
On inquiry, it was found that the cause of accident was due to fatal road accident while trying to overtake a taxi on a narrow curve road by the scooter rider, Lal Machula. So, the scooter rider was trying to overtake a taxi and hit an oncoming maxicab. So, on inquiry, it was found that the cause of accident was due to fatal road accident while trying to overtake a taxi on a narrow curve road by the scooter rider, Lal Machula, and then hit the oncoming maxicab, driven by J. Zonun Sanga, as a result of which the scooter rider succumbed to his injuries and heavily damaged both the scooter and the maxicab. The driver of the maxicab was examined and stated that he was collecting passengers and was driving from Ramhun towards Zarkot. One taxi had drove past him from the opposite direction, and on a split second after that, one scooter suddenly appeared from the bend at very high speed and thus hit the maxicab and lay flat on the road, heavily damaging the scooter and the maxicab as well. Now, next part is important. From the light of the inquiry, it has been ascertained that the cause of accident on the morning of 25th 8, 2018 at Chalmari happened as a result of the narrow curve road condition of the road and the high-speed driving on the part of the scooter rider, Lamachwana, where the scooter rider later succumbed to his injuries. So this is very clear, my lord. This is an uninterested person. He's a police. And he has said the cause of accident is this.
According to you, since the accident had happened at the negligence of the
Deceased himself.
therefore the
Claim under 166
is not
cannot be undertaken.
maintainable.
Not maintainable.
This is what you are trying
Yes,
to.
I will show the judgment also. And my lord, the this case IO was examined in the trial court, and his testimony was not shaken at all. In fact, he has stated he was arraigned as the claimant's witness itself. So he was arraigned as claimant witness number 4. So it is their own witness who have stated that, my lord, if your lordship have the investigating officer deposition, he is the claimant witness number 4.
Yes, Clifford.
Clifford, my lord. If I may take your lordship to the in chief is actually the same thing, and if I take your lordship to the cross-examination at page 3.
Page?
Cross-examination, my lord. The handwritten cross-examination by the learned counsel for the office.
Cross-examination of the IO.
The IO.
Yes.
My lord, if you have the first cross, exhibit C 13A is my signature.
Yes.
Yes. On the last paragraph.
Yes.
It is also a fact that the scooter and the maxi cab were on the same spot when the accident took place. What he's trying to say here is
One
that.
second. What?
Yes.
It is.
What he's trying to say here is
No,
that.
which one are you reading? Because
The last paragraph.
last paragraph says it is also a fact that the pillion rider and rider of the said scooty
Were already
were
evacuated
already
to the civil
evacuated.
hospital when I reached the site. And the next part, it is also a fact that the scooter and the maxi cab were on the same
That
spot.
I don't get.
Hello?
Why is it not here? Why that paragraph is not here?
Is it on the next page?
LC. Show. It's not there. So that means there is some defect. No, then anyway, it has to be. You ask your junior to just write that down, and I can put it here because otherwise my copy appears to be. It's not there. Mr. Benjamin, both of you can give me that what is not available at 45 of the case records. Here there is a pagination. It's page number 45. The cross doesn't appear to be complete.
Gotcha.
All right. Both of you can together give it, then there will be no confusion.
So while the junior is writing, but what it basically says here is that when the case IO reached the spot, the vehicles were in the same position as the accident took place. There was no movement of the vehicles.
The vehicles were together.
In the same place. And
Mr. Silo, I'll have to rise a little early. There is some meeting. You do one thing. You can check up the case records as regards the other testimonies. If there is anything else, you can, both of you together, just put it in a piece of paper if there is any illegible or anything in the cross-examination, and further hearing tomorrow.
My lord.
Further hearing.
Okay, man.
Obliged.
Keep.
Lord, came now.